Not what I wanted. That's what I wanted. Students, this week we're going to be talking about the judicial system. Before we get started, there are some terms I want you to know. These are going to apply to both criminal and civil law. We are under an adversarial system. And what I mean by this is we are opponents. This is not a friendly game you are playing to win. On one side, you have the plaintiff. The plaintiff is the accuser, the one making the accusation. On the other side, you have the defendant. The defendant is simply the person who is being accused. Texas law can be broken down into two categories. This is going to be civil law and criminal law. We're going to start off with civil law. I have provided a link to the various civil codes in Texas. All right, so if you see law, statute is also another word for a law. What we need to remember about civil law is that civil law is going to deal primarily with an individual's rights or property rights. The main difference between criminal law and civil law is the action. What are we attempting to do? In civil law, the purpose is to assign responsibility and not guilt. We don't care who is totally guilty, or we don't care who's guilty. We care who is responsible for the action. The plaintiff and the defendant are often private parties, individual suing an individual, individual suing a corporation. However, the government can be a member. In a civil lawsuit, the government can be a member. Can you sue the government? Yes. Can the government sue you? Yes. So even though the plaintiff and defendant are often private parties, this is not always the case. Disputes are usually set out in a petition. This is just you are presenting what you consider the facts of the case. It shows how you have been harmed. Now remember, harm does not have to be physical harm. To win a civil case, the level of evidence or the level of proof you must reach is called a preponderance of evidence. We can actually associate a number with preponderance of evidence, and this number is simply 51%. If you, the accuser, are saying the defendant is guilty of harming you, or not guilty, responsible for harming you in some way, shape, or form, you must prove that the responsibility is at least 51% or higher, or that the defendant was at fault for at least 51% of the accident or higher, of the incident or higher, of the harm or higher. Remedy is relief from or compensation for the violation of legal rights. Compensation, very easy to understand. It is money. An example of this. You're driving along, somebody runs a red light and hits your car. If you can prove that they are more than 51% responsible, your car is injured, they are responsible for fixing the damage to your car, purchasing you a new car, whatever. They're going to be held responsible. What is relief from your violation of legal rights? I mean, compensation, money is easy to understand. But what other ways? What is this relief from? How else can you be harmed? Well, there's other options here. It could be something as simple as if you're disputing a land boundary. Has your neighbor built something on your property? One relief from this violation of legal rights is you can force him to move his building, whatever he built on your property. If he crossed the property line, they can be forced to tear it down and build it on their property. Another example of this is if we're talking, you're in the city. The city passes a noise ordinance, or the city has a noise ordinance. It says that music cannot be played past a certain decibel, louder than a certain decibel past midnight. Well, you happen to live across the street from a club. Well, you go to bed and midnight comes and goes and they don't turn the music down. Are you harmed if you can't get sleep? Yeah, lack of sleep can harm you physically and mentally. So what you could do is you could sue in civil court if you can prove the preponderance of evidence, if you can prove that the nightclub or whatever we're talking about is 51% or higher responsible for your harm, they will be ordered, or they will lose the case. Remedy, or the relief from this could be something as simple as the court orders them to turn down the music. No money involved, but you win. You are not being harmed anymore. Preponderance of evidence seems pretty straightforward. Who was the most responsible? But sometimes it's just really not that simple. If you're going down the highway and you're doing 90 miles per hour, the speed limit 75. You are speeding. You come up on a crossroad. You have a caution light. However, the people that are going to cross your main thoroughfare have a red light. What happens if they pull in front of you and you hit them? Who is responsible? Well, the obvious answer is that, well, they're responsible. They didn't stop at their red light. But what if you wouldn't have been going 90? What if you wouldn't have been breaking the law? If you were going slower, you would have been further back. You wouldn't have been here to hit them. And maybe you would have had time to have stopped. See, sometimes this preponderance of evidence isn't as clear-cut as we think it would or should be. We have to consider all aspects of the incident. We have to consider all aspects of the case. Criminal cases. Criminal cases deal with behavior. Deal with proper behavior as defined by the Texas Penal Code. This tells us what we can and cannot do. You see, I've included a link to the Texas Penal Code. It'll tell you everything that is an offense. Chapter 21, sexual offenses. Chapter 20A, trafficking of persons. Chapter 20, kidnapping and unlawful restraint. Chapter 28, arson. Chapter 29. Where is it? Chapter 42, disorderly conduct and related offenses. Disorderly conduct, riot, obstructing highway or other passageway, disrupting meeting or procession, funeral service disruptions, harassment, stalking, abuse of corpse. We have a whole bunch of crimes here. Chapter 49, intoxication and alcoholic beverage offenses. 4902, public intoxication. 4904, driving while intoxicated. 49045, driving while intoxicated with child passenger. 4905, flying while intoxicated. 4906, boating while intoxicated. You know we have these because people did this. Yeah, these are our penal codes. These are everything we can do it will tell us, let's look at driving while intoxicated. It tells us when a person commits an offense. It tells us what type of offense it is, a Class B misdemeanor. So, this is what the penal code does. This is what it's for. In a criminal case, the case is initiated by a government prosecutor. In a criminal case, at the trial level, at the lowest level, remember how I said in a civil case, the government can be any party. They can be the adversary. They can be the plaintiff. They can be the plaintiff, or they can be the defendant. They can be the accuser, or they can be the accused. At a trial level, the trial level is the lowest level in criminal law. The government is always the accuser. The government is always the plaintiff. Why is that? Well, because a person is accused of breaking a law that the government created. Specific charges of wrongdoing are spelled out. You are accused of breaking Penal Code 4904, driving while intoxicated. They'll tell you, and then they will give you what they see as the facts of the case. On February 2nd at 8 p.m., Mr. So-and-so was observed driving on whatever road. It tells you what happened, what led to the charge. The person being charged will enter a plea of guilty or not guilty. Guilty, yes, I did it. Not guilty, no, I didn't. Strict rules of evidence are used to evaluate. Strict rules of procedure, are used to evaluate evidence. There are certain formats, there are certain procedural rules that have to be followed to ensure the rights of the criminally accused are protected. Guilt here is the level of guilt, the level of evidence, level of proof, whatever you want to call it, is different than that of a civil case. Remember, a civil case was a preponderance of evidence. Guilt is proven beyond a reasonable doubt. So beyond a reasonable doubt is the level we are looking for in a criminal case. I was able to put a number, a percent, on preponderance of evidence. Remember, it's just 51%, or more than 50%, more than half. Can we put a number on beyond a reasonable doubt? No, we can't. It's going to be different for every person. We don't know what it's going to be to convince you, yes, they did it. Determination of guilt results in punishment. If they are judged not guilty, they are free to go. If they are judged guilty, we will discover that there are a range of punishments available. Community supervision was once known as probation. Our laws will have either a fine, or possibly incarceration, or possibly both attached to them, depending on the level or depending on the severity of the crime. We're going to start moving into courts now. But before we do, I want you to understand that courts have different jurisdictions. The first type of jurisdiction I want to discuss is original jurisdiction. Original jurisdiction is simply the authority to hear a case, to try a case for the first time. In a court with original jurisdiction, a judge is going to oversee the trial. The judge is going to oversee the procedure. And more often than not, a jury evaluates the evidence. Trial courts in Texas are courts of original jurisdiction. The other type of jurisdiction is something called appellate jurisdiction. Appellate jurisdiction is simply the power of a court to review the decisions of a lower court. So we're going to make sure, if we're going to appellate jurisdiction, we're going to make sure proper procedure was followed. So it does not involve a new trial. There are no new facts presented, no new evidence. All we're going to do is, we see proceedings are based on law, not fact. Were the defendant's rights protected? Was everything followed according to law? If the appellate court reverses the decision, it means that the legal process at the lower court was improper. They did something wrong. We need to remember that an individual waives the right against double jeopardy if they appeal a court case. If they lose a court case and they appeal, they are waiving their right against double jeopardy. And I'll explain that. I don't remember if it's this chapter or next chapter. I put in a chart here. This is how the court system works in Texas. In Texas, we have a 3-level court system. We have the trial court level, we have the appellate court level, and then we have our highest court, our court of final review. 3 levels, and looking at this chart, I understand this is kind of confusing because it looks like there's 5 levels. In reality, there's only 3. What we need to remember is that when we're looking at the justice courts, these are the justice of the peace courts, the municipal courts, the county court at law, and the district courts. These 3 levels are actually 1 level. These are our base level. These are what are known as the trial courts. So the justice court, the municipal courts, the county level court, and the district court all make up the trial level court. The Court of Appeals, the middle one here, is our mid-level, state intermediate appellate courts. This is our appellate level. The Supreme Court and the Court of Criminal Appeals are both the highest court in the land, or the highest court in Texas. Both of these courts make up 1 level of, it could be called superior court, or it is called superior court in some states. So our trial court is district, county, justice, and municipal. Our appellate level is the Court of Appeals, and our highest level is the Supreme Court and the Court of Criminal Appeals. I've included a link so you can see how other states have their court system set up, but we're going to start talking about these. I'm going to start by talking about the local courts. The lowest level of court, that lowest level in the chart, had 2 courts on it. One court is the municipal court, or the city court. So they have original jurisdiction over violations of city ordinances. So they are the first one to hear a case regarding a violation of city law. Municipal courts have limited jurisdiction. That means they only handle minor violations of state law. And these are the Class C misdemeanors. I'll tell you in a second. The punishment for a Class C misdemeanor is a fine of $500 or less. It does not include a jail sentence. And most of our cases for Class C misdemeanors, they're going to be traffic citations or parking violations, the non-serious crimes. The municipal courts are created by the Texas State Legislature under constitutional authority. This means that the Constitution says the Texas State Legislature can do this. So again, their jurisdiction, they have original jurisdiction in enforcement of city ordinances, so they're going to be the first to hear the case in enforcement of city ordinances and Class C misdemeanors originating within city limits, and in civil cases if it involves dangerous dogs. The number of municipal cases spread throughout the state of Texas. In 2012, there were 926 municipal courts. The caseload, the number of cases they hear. 926 municipal courts. Is that a lot? How many cases do you think they hear in a year? So their caseload for the fiscal year that ended in 2012, we saw 6.44 million cases that were tried in municipal court. They keep very, very busy. Municipal judges, even though they are a judge of a court of limited jurisdiction, they may also sign and issue search warrants and arrest warrants. The Justice of the Peace. This was the other half of that lowest level in the trial court. They have jurisdiction over criminal cases if the fine is under $500. However, the Justice of the Peace also has jurisdiction over civil matters, over civil law, if the dispute is less than $10,000. Like all other judges or justices, the Justice of the Peace has the ability to issue warrants for search warrants and signed arrest warrants. The qualifications to become a Justice of the Peace. You must be a registered voter. If you're not a licensed attorney, you must complete a 40-hour training course. And I provided a link to the training center so you can see what some of the courses are. That's it. Registered voter, if not a licensed attorney, a 40-hour course is required. If you're elected as a JP, you're elected to a 4-year term. Some of the duties you have, some of the responsibilities you have as a Justice of the Peace. You can perform marriages. If there is not a coroner and available, if there's not a coroner in the county, you get to act as a coroner. You get to declare cause of death. You are an ex officio notary. Ex officio means because you hold one position, you are automatically something else. If you think back to the chapter on the state legislature, when I was talking about some of these boards and that the presiding officers of the Senate or the Lieutenant Governor or the Speaker of the House, they were the ex officio heads of these boards or these commissions. That meant that they were head of the commission, they were head of the board because they were elected Speaker of the House. So a Justice of the Peace is a notary of the state of Texas because he or she was elected Justice of the Peace. That is what ex officio means. Then you also have small claims court. The Justice of the Peace courts, they're created by the Texas Constitution. So again, their jurisdiction, they have original jurisdiction over Class C misdemeanors, and they have small claims. The number, there's 820 in Justice of the Peace courts as of 2012. What we have to realize is that the Justice of the Peace courts are divided into districts or precincts. It depends on population. A county can have no less than 1, but they can have no more than 8. So this number can change. Caseload. In the fiscal year 2012, There were more than 2.58 million new cases which were tried in Justice of the Peace Courts. Other duties. They may issue search and arrest warrants like any other judge or justice. They serve as coroner in counties with no provisions for a medical examiner. I mentioned that earlier. Now this is neat. This is the one thing that the JP can do that nobody else can do. And that is they have the ability to sign eviction notices. So if you have a rental house and you have somebody who's not paying their rent, you just can't go kick them out. You actually have to go to a Justice of the Peace, get them to sign an eviction notice, and have a constable serve the eviction notice before you can legally kick out your renter. And a JP is the only one who can do this. I provided a flip book on the Texas judicial system. Oh, I did? No, they moved it. Oh well.